Hello, my name is Jade Hwang. I'm a foreign consultant at Nusantara DFDF Partnership. I specialize in cross-border M&A, corporate restructuring and joint venture. My area of focus is mostly on fintech, financial institution, energy, and also representing PVC on their investment across ASEAN region. Indonesia land legal framework is actually a hybrid version. It's actually a mixture of civil law, agrarian law, investment law, and the national land policy principle. A lot of time the confusion actually stems from the concept of ownership, which may differ from international concept. So, in a nutshell, in Indonesia, freehold title can only be owned by Indonesian citizen, while foreign company or private corporation can only hold the HGB title, which means the right to build. It's akin to legal leasehold title in other jurisdictions, but in Indonesia, that is the main ownership structure, which accord the private companies or foreign company the right to actually own, use, sell, and also mortgage such land right for a period of 80 years. So these 80 years is actually break down into 3 tranches. First, you will be awarded a 30 years lease or ownership, which can be extended for another 20 years. And lastly, renewable for the next 30 years. Yes, foreign company can actually own land, but on certain land titles, which awards them certain rights. The most common title that foreign investor can go for is actually the HGB title, which means the right to build. This is actually awarded to the foreign investor on a total of 80 years period, break into 30 plus 20 plus 30. Such right, in fact, gave them the rights to use, to sell, and even to mortgage. So for a HGB title itself, it's actually bankable, which means a foreign investor can actually put it up as a collateral with bank for financing purposes. As foreign companies are allowed to actually own, use, and even sell the property itself, there are actually 2 very common options that they can go for. One is through the HGB route, where they actually buy the land or property on a HGB title basis. Second would be the more straightforward lease basis. So this is the common structure that we have seen in foreign companies in leasing office, in also owning factories and warehouse for conducting their operation in Indonesia. In signing long-term lease, there's a few considerations that the foreign company must take into account. First thing first, I would always advise the foreign company to do a thorough land due diligence, because by conducting such land due diligence, we can uncover the historical land usage. We can delve into the land title and the land use itself. Because what is the point of buying a land and you later realize that that land is only reserved for either tourism or agriculture purposes, and you're not allowed to even conduct any industrial activity on such land. Apart from that, we also have to advise clients to consider whether there's any environmental assessment or impact on such land, coupled with any outstanding tax liability. This several scope is actually part of our usual land due diligence. Land DD in Indonesia is actually more on risk discovery and risk mitigation. The reason being is we have to uncover the historical development of the land. So there's a few issues or scope that we normally look into, such as land title, land tenure, and the land use. In addition, we also advise clients to look into the zoning, because subsequently this will also affect the land use itself. For example, in Indonesia, there's a lot of first-time mistake by foreign buyers where they bought the land for industrial purpose, and later on they found out that the land use is only confined to agriculture or tourism. Conversion to industrial can be done, but of course there's a lot of effort and time will be wasted in such process. At the same time, we also have to consider the current permit and licenses, environmental assessment, and also whether there's any tax or outstanding tax liability on such land itself. First thing first, they need to place importance on the land title, the land tenure, the historical development of the land, whether there's any encumbrance, whether they are allowed to carry out their intended operation on such land. At the same time, depending on the location of the land, for example, if it's in the industrial estate, most of the time such land title are pretty much clean, no issue, no ongoing dispute and so on. But if the land happen to be situated outside of industrial estate, that's where various issues may arise. So for example, overlapping of land title, the boundaries, inaccurate measurement, and to a certain extent, it will also affect future operation due to the neighboring of the community surrounding that land itself.